Assalamualaikum and good day. This arbitration concerns the issue of non-compliant material, specifically the substitution of imported tiles with local tiles, which later result in chipping and discolouring. We will begin with the claimant statement of claim.
Okay, we remind both parties that all submission must be supported by P.W.D 2038 clauses and documentary evidence. So we continue with Claimant.
Okay, thank you, arbitrators.
We submit that the respondent has breached the contract by substituting the specified important tiles with locally sourced tiles without obtaining prior approval from the Superintending Officer as required under the contract. After handover, the tiles were found to be defective, including chipping and discoloration. We will show that this substitution was unauthorized and the respondent is contractually responsible for rectification.
Now, to support my claim that the contractor has breached the contract specification, I would like to present this bundle of evidence. Firstly, for Exhibit 1, the specification sheet clearly stating that imported grade A tiles were required. Then, Exhibit 2 show that photos taken after handover showing the chipping around the tiles edges and noticeable discoloration. Next, under P.W.D Form 203A Revision 1st 2010, the contractor is required to use material of the kind, quality and description as specified in the contract, and any substitution must obtain prior approval from the architect. In this case, no such approval was obtained. For the fourth evidence, in Young and Martin Lead v. McManus Chart, it is established that substitution material without the employer's or architect's approval constitute a breach of contracts. And lastly, in the local case Sunisas Syndrome Berhad v. Kerajaan Malaysia 2022, the court emphasized strict compliance with P.W.D procedure and failure to follow approval processes in considered a breach. Based on the evidence, it is clear that the contractor acted outside the contract specification and failed to meet their obligation.
Thank you, Respondent 1. Please proceed.
We do not deny that a substitution took place. However, this was due to unforeseen supply chain shortage, which made the specified imported tiles unavailable. The substitution was carried out in good faith to avoid project delay and ensure completion of the works.
Arbitrator, in response to the allegation that we breached the contract, I would like to present the following evidence. So, firstly, there is a supply letter confirming shipment delays of the important tiles. So you can see. So for the next page, this delivery recordings to extended postponements. So next, this is the under P.W.D Form 203A. So revision 1/2010. So the contractor is allowed to request material substitution in the event of supply issue or other unforeseen obstacle. So in this case, the substitution was due to supply chain shortage beyond our control. So, and according to Anas Construction Sdn Bhd versus JKP Sdn Bhd, court has recognized that contractor may need to make material change due to technical or supply issue, and leniency is considered if effort was made to seek approval. And this is the last, and this is general contract principle and common law. Allow that in situation or practical impossibility, reasonable action can be taken to continue the works, including using alternative material while awaiting approval. So, based on this evidence, we submit that the tile substitution was a reasonable measure due to supply constraint and does not constitute an absolute breach. Thank you.
Claimant, do you wish to reply briefly?
Yes, Your Honor. While the respondent cites supply issues, the contract clearly requires prior approval before any substitution. No approval was sought or obtained before the tiles were installed. Good faith or urgency does not override the express requirement of the contract. The respondent's failure to follow the approval procedure is the core issue before this.
Respondent, do you wish to reply to the claimant's clarification?
Yes, Your Honor, briefly. We do not dispute that prior approval is generally required under the contract. However, we submit that the circumstances of this case must be considered. The substitution was carried out due to genuine supply chain shortage which were beyond our control. Delaying the works while awaiting approval would have resulted in significant delay to the project, contrary to the objective of timely completion. Furthermore, there was no immediate objection raised at the time of installation, and we act in good faith with the intention of regularizing the substitution. We therefore submit that the substitution should be viewed as a practical decision rather than a deliberate breach of contract.
Having considered the submissions and evidence of both parties, the Tribunal finds as follows. The contract under P.W.D Form 203A Revision 1, 2010 clearly requires compliance with material specifications and approval prior to any substitution. While the Tribunal acknowledged the respondent's supply difficulties, which the respondent failed to seek approval from the Superintending Officer, as required under the contract. Pursuant to Clause 48, the respondent is responsible for rectifying defect arising from non-compliance material.
So now, this hearing is now closed.
Renata nama macam ni, Arbitration ni aku cakap semua yang sampai. Apa sudah? Kalau aja